Here are 3 of my most important tips for handling stress during litigation, whether you are the plaintiff in a case or whether you are the defendant. Number 1, let your lawyer do the job. You focus on your life, focus on the things that are important to you in your everyday life. Your job, if you have one, your family, your children, your school, your fitness. Realize that litigation is a process that takes time. No matter how much you want everything to be settled and resolved today, it's probably not going to happen. Most cases take months, and often they take a year and a half, or even longer to resolve, whether they settle or they go to trial. There is nothing you can and there is nothing you should be doing to speed up the process. It's simply impossible. Courts have a lot of cases. Your lawyer has a lot of cases. The lawyer who represents the other side has many cases. Everybody gets their turn, but you got to be patient and you have to wait. My second tip is very simple, but it is also very important to keep in mind. If you're involved in a civil dispute, you have to think of the worst case scenario and whether or not you can survive it. For example, if you've been fired and you filed a case for wrongful termination, and it's a very personal case to you, it's a very emotional case, what is the worst thing that can possibly happen in your case? You go all the way to trial, you lose, and somehow the court awards a certain amount of money, a relatively modest amount of money in costs to the other side. So you may end up owing $5,000, maybe $10,000 to the other side. This is absolutely the worst case scenario in an employment case usually. And given that the vast majority of cases settle before trial, and given that many people actually win, many plaintiffs win their cases, if you can live with that worst case scenario, then you can live with anything else that's better. And the most common outcome is some type of settlement. It might not be a perfect settlement. It might be a settlement for a smaller amount that you hoped for. But if you can live with the worst outcome, you should certainly be able to live with anything better than that. So in a sense, you don't have much to lose, and therefore you should not be that worried about the process. You should not be that stressed out. It is not a criminal case. No matter what happens, you're not going to jail, and the other side is not going to jail. And the third important tip that I have for you is this. A lot of people are stressed out in litigation because they are afraid that their lawyer is not doing their job. Maybe they're neglecting their case. Maybe they're too busy and they don't care about their case. In order to avoid this type of stress, you should talk to your lawyer in the very beginning of your case, during your initial consultation. You should talk about your respective expectations when it comes to communication. Your lawyer might tell you, and he should tell you, look, you don't have to contact me. If I have news, I will update you. But if you don't hear from me in 60 days, please check in with me. You should be asking your lawyer in any type of case, hey, if I email you, if I call you, how soon will you usually get back to me? And your lawyer will tell you, I will get back to you within 2 days. And then you could ask your lawyer, what's better, to email you or to call you? What's better for a faster and for a better response? How can I make sure that I get the response as a client that I need? And how can I make sure that I don't create more work for you than necessary? If you have correct expectations from the very beginning, then you will take all the stress out, because the stress comes from the unknown. The stress comes from wondering what's going on with my case. The stress coming from not having trust in your attorney because you did not set correct expectations. Let me give you another example, and this goes back to the second element of what's the worst thing that can happen. Let's say that you've been injured in a car accident, or you suffered a slip and fall and you fractured your ankle, or you broke your knee, or whatever else. The worst thing has already happened to you. If you weren't able to work, you lost wages. If you've been injured and you incurred bills, medical bills, then it has already happened. the worst physical pain has already happened. Nobody's going to take anything away more from you. From this point forward, you're going to get some compensation. Maybe it's going to be more, maybe it's going to be less, but you're probably going to get something, unless there is some kind of unforeseen circumstance, such as no insurance coverage, or the other side declare bankruptcy, or one of the other limited possibilities. Otherwise, you should be recovering something. So if you know that you're going to get something, and if you know that you're not going to walk away with nothing, and you know that you're not going to jail, and the other side that injured you negligently, not intentionally but negligently, you know they're not going to jail, you should not be stressing out too much about your case. You should be taking care of yourself, of your health, of all the other things in your life, and you should let your lawyer handle that part of your life, that case, because that's what you're paying them for. And the last tip, it's a little bit of an unusual, unorthodox tip that I would like to give you, is this. You should care about your case, but you should not be caring too much about it. And what am I trying to say? If I could draw an analogy, in sports, maybe in tennis, in baseball, they often say you should be throwing a ball or you should be hitting a ball with 80% to 85% of your power. When you put all your power into that strike, you're likely going to miss hit, or you're going to dislocate your shoulder, or you're going to injure yourself. It's true in sports, and it's often true in law, in litigation. You do not want to lose sleep and work on your case day and night and obsess over every little detail and over every tiny little word in every document. It's not important. Your lawyer and you should discuss what's really important in your case, what you should be doing, and what you should not be doing. By obsessing over your case, you're not doing anything good for your case. You're not doing yourself any favors, and you don't benefit the outcome of your case. In fact, looking at the big picture and doing the things that make your case stronger as a whole is much more important than getting caught up with little typos, little details. Not to say that they don't matter, but you got to keep perspective. You should not be neglecting other parts of your life. And if you've been terminated, you should not be neglecting your job search for pursuing your case. And if you've been injured, you should not be neglecting your recovery, your physical therapy, your medication. You should not be neglecting that for the sake of working on documents and doing your own legal research and so forth. You're only going to confuse yourself, stress yourself more than necessary for no reason. So don't do that. Keep these tips in mind, and they will help you reduce the stress associated with litigation in your case, or eliminate it altogether. Thank you.